Starting on September 21st, any H-1B petition being filed will need to be accompanied by a fee of $100,000. Hey everyone, if you are at all involved in business immigration, employment-based immigration for the past weekend, you must have heard about this news about the $100,000 fee that's now going to accompany all the H-1B petitions filed after the date of September 21st, 2025. The Trump administration arbitrarily issued an executive order imposing this fee, and because he has control over the executive branch, all the agencies under the Department of Homeland Security have modified their regulations to allow for this fee. We don't know a whole lot yet, only that this is $100,000, that it appears to be a one-time fee. I have heard rumors online that this is going to be an annual fee, but that doesn't appear to be the case based on the agency announcements. It is not clear whether the petitioning employer will need to pay the $100,000 fee if it is an extension request, an amendment request, or just a job transfer request from the employee's previous H-1B position. I suppose we will find out more in about 90 days, which is the deadline that those agencies are given to execute the executive order issued by the president. Here's what's important. If you already have an H-1B petition pending before September 21st this year, you are safe. If you already have an H-1B petition approved, you are safe. If you already hold an H-1B visa and you have not yet entered the United States, you are safe. The agencies under DHS, including USCIS and CBP, have all issued memoranda confirming these points. And meanwhile, the Department of State, while they have not issued any memo, they did put up an FAQ page that also confirmed that they will comply with the executive order in these ways. Once the rules come into effect, they will stay in effect for a period of 1 year, at the end of which the White House will decide whether to extend these rules for further years. So this may not be the end of the H-1B, and indeed a lot of things can happen between now and 1 year later. This policy is going to affect more than just tech workers. I can speak from personal experience that H-1Bs could apply to people like those working in funeral homes, nonprofit researchers, civil engineers, and psychologists. So what does the future hold? I imagine tech companies aren't going to be very happy with this change, but only time will tell if any one of them is willing to step up and actually challenge the administration through lawsuits. I understand that some law firms are already gathering the H-1B workers who are impacted by this rule in order to initiate some sort of class action lawsuit. But we will see how those lawsuits go. In the meantime, if you are somebody who is relying on H-1B, or you are planning to rely on H-1B to continue or stay in the United States so that you can build a career here and eventually naturalize here, I want you to consider some alternatives. If you are a national of Canada, Mexico, Singapore, Australia, or Chile, there are other visa categories that are similar to the H-1B that might be able to extend your stay in the US. If you're somebody with a substantial level of achievement in your field, I highly encourage you to look into this category of visa called the O1. The O1 visa is typically reserved for people with extraordinary abilities, but one of the things I always tell my clients is not to self-select out. Let your lawyer decide whether you qualify your O1. If you have a better than average performance, there might be a good chance that you might qualify for the O1 visa. And if you're able to get the O1, then you can at least extend your stay long enough for you to start applying for permanent residency down the line. Alternatively, you might consider applying for permanent residency now. Typically, those who hold the H-1B will eventually apply for something called PERM, which allows them to obtain a green card through the EB2 and EB3 visa categories. You might consider applying for the EB1A, which is the big sibling version of the O1 visa based on extraordinary ability. You might consider applying for EB2 National Interest Waiver, which allows you to self-sponsor for the work that you do that is to the United States national interest. There are some paths that allow you to stay in the United States even if H-1B is no longer in the picture. There are, of course, other immigration paths, for example, through family and investment. If you're looking for options, talk to us. Until next time, guys.